We're joined now by Scripps News legal analyst Michael Scotto. He's a former Manhattan Assistant District Attorney, as well as the former Rackets Bureau Chief, and Vinoo, a Wall Street criminal defense attorney. Let me start by asking you both what stood out most during the testimony today. Michael, lead us off.
Well, I think the prosecutor got out what they wanted to get out, which was to have Mr. Pecker talk about meetings, specific testimony regarding this scheme that they're alleging to, catch and kill. And that's really what the theme of the opening statements were, that this is more than just some cold business records. This was a scheme to influence the election. Mr. Pecker was able to actually discuss his conversations with former President Trump over the last 2 days, and also his conversations with Michael Cohen to, lay that out. It's yet to be seen, how this first scheme to catch and kill ties into the false business records. Obviously the DA is going to try to make the argument that these false business records also were intended to conceal the commission of these alleged federal campaign finance violations. But again, it's yet to be seen if there'll be any direct evidence of that.
Vinoo, how about yourself?
Well, I think this is the beginning of what I think is going to be a very difficult case for the district attorney to prove legally, but because the trial is in Manhattan, is in New York City, where Trump is mostly reviled, the conviction is a foregone conclusion. The problem, for Trump is a bigger one, which is that this judge is going to put Trump in jail once this case is over. Once he's convicted, the judge is going to put him in. David Pecker's, this hush money trial, as your analyst just said, how do these relate? I think it's background information. I think it's noise. There's nothing illegal in what David Pecker was testifying about, but it's all just going to provide more fodder for the prosecution to ultimately get the first conviction against the former president.
Yeah, and as you both were saying, a lot of today's testimony, day 2 testimony, was from David Pecker, and much of it focused on the practice of catch and kill, something that we've heard about throughout the years. Michael, what about this would make it unlawful?
Well, the unlawful nature isn't the fact that they were paying to, hush money, right? It's that these were alleged to have been payments by the National Enquirer, which would have exceeded the federal election limits for contributions. And that's, in fact, one of the two crimes that Michael Cohen pled guilty to in federal court, was to campaign finance violations for those payments. And as far as Mr. Pecker goes, he entered into a non-prosecution agreement with the Southern District of New York, the federal prosecutors who prosecuted Mr. Cohen. So the concept is, if somebody wants to suppress damaging information, if it's in the context of a campaign and they're paying out of their pocket and it's in excess of what the contribution limits are, that's a federal violation. And the DA is using that to bootstrap the, A misdemeanor or the false records to make it an E felony. But that's why it's illegal. At least that's the theory.
Yeah, an important distinction there. Vinoo, give us your take on how the defense is responding to these claims of catch and kill.
Well, I think Todd Blanche, who I know, I had tried a case against him when he was in the Southern District. His opening was, I thought, on point, solid, that none of this was designed to hide anything criminal. All it was designed to prevent Donald Trump personal embarrassment. And, there's another factual problem here, is that these payments occurred after, or these business records occurred after the 2016 election. So to say that a state prosecutor is here, and your analyst used the word perfect, had the perfect word for it, bootstrap, trying to attach a potential federal crime or an alleged federal crime to make a state crime that didn't exist. It's never been tried in this fashion in a New York State court, these kind of cases. So, look, this is stretching things beyond what we'd call in the legal circles, credulity, or in layman's terms, this is nonsensical from a criminal standpoint. But, you know, the show will go on and Trump will get convicted. And I know this judge is going to incarcerate him and he'll go down as the judge who incarcerated Donald Trump.
Yeah. Well, during his testimony, Pecker was asked about his meeting with Michael Cohen and Donald Trump in 2015. There was a story involving a doorman. Pecker went on to talk about what he would then do for Trump and Cohen, saying in part, what I would do is I would run or publish positive stories about Mr. Trump, and I would publish negative stories about his opponents. And I said that I would also be eyes and ears. I said I would be your eyes and ears. Michael, how is the prosecution going to use testimony like this to prove that what Trump did was actually illegal?
Well, what they're trying to do, again, is to get into that federal law with campaign contributions, that these were in-kind contributions by buying these stories and suppressing the information so that the voters, didn't know about them. And again, that's the DA's theory, and certainly Mr. Cohen pled guilty to those federal offenses. But the real question is whether or not, again, former President Trump had the intent when these business records were created, which the DA alleges are false, to actually conceal another crime. And in this case, one of them is a federal election crime. Another is a New York misdemeanor for unlawfully influencing an election. So that's why the DA brought it out, because they believe it's important to show that Mr. Trump and Mr. Cohen and Mr. Pecker all knew that this would have some sort of an effect on the campaign. It wasn't just about personal information that he didn't want getting out. Although, again, I thought it was significant that Mr. Pecker testified that at first blush, former President Trump didn't think it was a good idea to pay Ms. McDougal. So, and he arranged it with Mr. Cohen. So certainly that was not a bad bit of evidence for the former president.
All right, we have to sneak in a quick commercial break, but both of these guys are staying right here, and we hope you do too, because we've got much more to come. Before the start of the hush money trial, the judge banned Donald Trump from publicly attacking witnesses, jurors, and others associated with the case. But the prosecution says he's done it anyway, quote, willfully and flagrantly, multiple times. They want the former president held in contempt. But will the judge agree? And if so, what are his options for punishing Trump? I'm back with Scripps News legal analyst Michael Scotto, a former Manhattan assistant district attorney, and Vinoo Varghese, a Wall Street criminal defense attorney. Michael, Trump's attorneys say they're trying to comply with this gag order. Judge Merchan responded, the Trump team is losing all credibility with the court. How do you see this playing out?
Yeah, I mean, the trying to comply with the order, that sort of, as the judge pointed out, strains all credulity, right? Look, the judge is obviously concerned. They held a hearing today. These instances do appear to be, violative of the gag order. Former President Trump's lawyer today said, well, he was just responding to political things. And the judge said, well, you could have come back and asked me if you could do that, right? Didn't happen. He didn't buy the argument that retweeting was not making a comment. In my view, though, the issue is, how are you going to stop him? Is a $1,000 fine going to stop him? And the idea is when you bring a contempt proceeding, it's to either punish somebody or get him to comply with a court order. And I don't know that there's anything the judge can do that will get former President Trump to stop doing things that are contrary to the order.
Yeah, I was going to ask you really quickly, Michael, do you think Trump would actually be deterred by that? Or how do you think the court could actually, effectively enforce the gag order?
Well, look, there's a $1,000 maximum fine or 30 days in jail. The only case I recall, and it was over 25 years ago, there was a New York businessman, Abe Hirschfeld. He took out full-page ads in various newspapers while he was on trial for tax evasion. There was a hung jury, and afterwards the judge held a hearing, found him in contempt, and sentenced him to 90 days in jail, right? And so is that something that I think is going to happen here? No, but there is that possibility. On the other hand, if you send President Trump to jail, you're turning him into a martyr, and it looks more like a political prosecution. And frankly, I think a $1,000 fine, he couldn't buy publicity for $1,000, right? That's priceless. So I'm not exactly sure, how this is going to play out, but I don't think that it's be interesting to see what the judge does.
Yeah. Vinoo, let's bring you back in. Did the Trump team have some meritorious arguments here, or did Todd Blanche just get off on the wrong foot with the judge with all of this?
I think the more important question is how the judge is being perceived. So there's United States Supreme Court case law that says that there are limited situations in which a court can prohibit speech, and there's cases that went up to the United States Supreme Court. One involving a criminal defense attorney named Gentili in the state of Nevada, and you can do so to an extent. And I think that's the problem here, that this gag order is a First Amendment violation. While you can do it to an extent, and I think that some of it's fine, don't insult court staff, don't insult maybe the prosecutors who are there. The issue is, what are you trying to do here? And when you attack a defense lawyer, and the entire world is basically watching right now and saying he has no credibility, you as a judge are now putting yourself into the case when you don't have to. You say, Mr. Blanche, what do you think? Why should I not impose some sort of fine here? So it's okay, let me take it under advisement. Thank you. I am going to impose a fine. Here's why. I find that it violates my order. It's that simple. You don't need to take what we call in the law in Latin an ad hominem attack when you attack the man. I think that's a problem. And Merchan is really showing where his cards are, that he is just itching to put Trump in jail.
Well, yeah, if Trump continues to violate the gag order, could he actually go to jail? And what would that look like?
I mean, he could, but I don't think he's going to do it during the trial. I think he's going to just issue some fines, but I have no doubt that he wants to put him in there. And I think that, you can only restrict constitutional First Amendment protected speech when it poses a substantial likelihood of material prejudice. That's the language from the U.S. Supreme Court case. So what that means is, unless it's going to somehow throw the trial off. Nothing Trump says is going to throw the trial off. In fact, if he's prohibited from insulting Michael Cohen is allowed to insult him. Michael Cohen has gone on everywhere insulting Trump. So I don't believe it's fair. I don't believe it's right. And I think ultimately, if this issue were to get to the U.S. Supreme Court, the court would find in favor of Trump, and that this was unduly restricted speech. There's no analysis from the the state appellate court. It just said motion denied. There's no analysis whatsoever, and that's different from the D.C. Circuit Court, which analyzed the issue and actually rejected parts of the gag order that was put on by the D.C. District Court.
All right. Michael Scotto, Scripps News legal analyst and former Manhattan Assistant District Attorney, and Vinoo Varghese, Wall Street criminal defense attorney. Thank you both so much for your time and insight tonight.